I don't know. Good afternoon. Welcome to the Assembly Committee on Health and Human Services. Secretary, will you please call roll?
Assembly members Dahlia, here. Edgeworth, present. Gonzalez, here. Goulding, here. Gray, Hafen, here. Hibbets, here. Hunt, here. Jackson, here. Koenig, here. Nadeem, Wynn, Orntlicker, Chair Brown-May.
Here, thank you. If you please mark Assemblymember Gray present when he arrives or absent excused if he doesn't make it in time. I want to thank you and welcome everyone here in the room in Carson City and anyone who may be joining us in Las Vegas and everyone on the line. Today we have a work session on our schedule today. So some housekeeping, please a reminder to silence your electronic devices. If you want to testify in public comment, which we will take at the end of the meeting, please sign in at the table. Our meeting agenda is available on YouTube and on the Nellis website. Please be courteous and respectful, and committee members may be using their laptops. So today, we are not planning to rehear any bill that has been heard or is on work session. However, we may call up someone to answer questions as we move throughout the day. And we will start with Assembly Bill 551, and I will turn this over to Mr. Florence.
Thank you, Madam Chair. Davis Florence, Committee Policy Analyst for the record. Assembly Bill 551 requires a background investigation of employees, prospective employees, contractors, and prospective contractors of the Division of Welfare and Supportive Services. This was sponsored by the Assembly Committee on Ways and Means on behalf of the Office of Finance in the Office of the Governor and was heard on May 9th. AB 551 requires DWIS of DHHS to obtain information on the background and personal history of prospective employees and contractors from the appropriate law enforcement. And there are no amendments to this bill. Thank you, Chair.
Thank you, Mr. Florence. Members, any questions? Seeing none, I will entertain a motion to do pass.
So moved.
Motion by Vice Chair Wynn, second by Assemblymember Hunt. Is there any discussion on the motion? None. All those in favor say aye.
Aye.
Any opposed, nay. Motion carries unanimously. And we'll give that floor statement to Assemblymember Jackson. Next on our agenda is Senate Bill 137. Mr. Florence.
Thank you, Chair. Davis Florence, Committee Policy Analyst for the record. Senate Bill 137 requires the establishment of a program relating to medical emergencies and was sponsored by Senator Neal. This bill was heard on April 25th. SB 137 requires the Division of Public and Behavioral Health to establish and operate a program to improve the ability of people to respond to medical emergencies, including the ability to access resources. And there are no amendments to this bill. Thank you, Chair.
Thank you, Mr. Florence. Members, any questions? Seeing no questions, I'll entertain a motion to do pass. Motion by Vice Chair Wynn, second by Assemblymember Hunt. Is there any discussion on this motion? No discussion. All those in favor say aye.
Aye.
Any opposed, nay. Motion carries unanimously. We'll give that floor statement to Assemblymember Goulding. Thank you. Next on the agenda is Senate Bill 183. Mr. Florence.
Thank you, Chair. Davis Florence, Committee Policy Analyst, the record. Senate Bill 183, in its first reprint, revises provisions relating to caseworkers of agencies which provide child welfare services. This was sponsored by Senator Scheibel and was heard on April 28th. SB 183 prohibits a child welfare agency from assigning more than 30 children who are in its custody to a caseworker who provides permanency services, and there are no amendments to this bill. Thank you, Chair.
Thank you, Mr. Florence. Members, any questions? Seeing no questions, I'll entertain a motion to do pass.
So moved.
Motion by Vice Chair Wynn. Second by Assemblymember Dahlia. Is there any discussion on this motion? Assemblymember Hafen.
Chair, I'm going to be a no out of committee. Hopefully I could get to a yes on the floor on this one, but right now I'm going to be a no out of committee.
Thank you. Any other discussion? Okay, all those in favor say aye.
Aye.
Any opposed, nay. Nay is Assemblymember Hafen. Thank you. Motion does pass. We will assign that floor statement to Assemblymember Wynn.
Thank you.
Thank you, Vice Chair. Next on our agenda, we have Senate Bill 187.
Thank you, Madam Chair. Davis Florence for the record. Senate Bill 187, in its first reprint, revises provisions relating to child welfare. This was sponsored by Senator Pizzina and was heard on April 23rd. Senator Pizzina did submit the attached amendment, which in summary proposes to replace medical or mental health treatment to instead read non-emergency medically recommended care, and requires a child welfare agency to provide or deny consent within 14 calendar days of the assigned caseworker being provided with written notice of medical recommendation or a referral for care. The second item revises that a child welfare agency shall make reasonable efforts to obtain consent for treatment. The third item replaces, similarly to number one, replaces medical or mental health treatment with non-emergency medically recommended care. And the fourth item adds new provisions stating that nothing in Section 2 shall be construed as preventing any party withstanding from seeking a court order for the medical treatment of a child in the custody of a child welfare agency. Thank you, Chair.
Thank you, Mr. Florence. Members, any questions? Seeing no questions, I will entertain a motion to amend and do pass.
So moved.
Motion by Vice Chair Nguyen. Second by Assemblymember Dahlia. Is there any discussion on this motion? Seeing none, all those in favor say aye.
Aye.
Any opposed, nay. Motion carries unanimously. We'll give that floor statement to Assemblymember Dahlia. Thank you. Next on our agenda, we have Senate Bill 284. Mr. Florence.
Thank you, Chair. Davis Florence for the record. Senate Bill 284, in its first reprint, revises provisions relating to child welfare. This was sponsored by Senators Canizaro, Scheibel, and Nguyen et al., and was heard on May 5th. SB 284 requires an agency that provides child welfare services to determine if each child in its custody is receiving or is eligible to receive certain federal benefits within 60 days of custody and annually thereafter, and apply promptly for federal benefits on behalf of the child if the agency determines a child is eligible but is not currently receiving benefits. And there are no amendments to this bill. Thank you, Chair.
Thank you, Mr. Florence. Members, any questions? Seeing no questions, I'll entertain a motion to do pass.
So moved.
Motion by Vice Chair Nguyen. Second by Assemblymember Dahlia. Is there any discussion on this motion? Seeing none, all those in favor say aye.
Aye.
Any opposed, nay. Nay is Assemblymember Hafen. Thank you. Motion does carry, and we will give that floor statement to Assemblymember Goulding. Thank you. Next on our agenda is Senate Bill 295. Mr. Florence.
Thank you, Chair. Davis Florence for the record. Senate Bill 295, in its first reprint, revises provisions relating to food establishments. This was sponsored by Senators Doñate, Flores, and Assemblymembers Gonzalez, Moore, and De Silva, and was heard on May 7th. There are three amendments for this bill. The first was submitted by Senator Doñate and is also attached, which proposes to clarify that in Section 6, the provisions of NRS 446.861 and the applicable sections of this act only apply to a local board of health in a county whose population is 100,000 or more, or a city in a county whose population is 100,000 or more. Second item includes tea that is not pre-packaged and is prepared on site. Third, clarifies that subsection 1J of section 10 does not include dairy products. Number 4, removes paletas from section 10. Number 5, revises subsection 1O of section 10 to instead state any other food or non-alcoholic beverage items as deemed permissible by a local health authority. Additionally, Senator Doñate's amendment adds in section 11.5 provisions that authorize a local zoning board, planning commission, or governing body to adopt any ordinance or regulation relating to cottage food operations or sidewalk vending to protect public health and safety. The additional amendments limit that establishments are no more than 150 square feet of total storage and display area, and that a sink is not more than 10 feet away from the conveyance and without any structural impediments or physical barriers between them. The second amendment was submitted by Assemblymember Brown May and proposes to require the food items be prepackaged or prepared in a commercial grade kitchen or at a conveyance. And then the third amendment, which was submitted by Joelle Gutman Dodson on behalf of Northern Nevada Public Health, which is also attached, This amendment proposes to establish application requirements for vendors, clarify the size and equipment restrictions, which require conveyance to be non-stationary, and that the cart size is limited to ordinances or regulations as determined by a county or city. This amendment also, in number 3, limits the food items that a sidewalk vendor may sell to those that are outlined in Section 10, and that a street food vendor is not classified as a food establishment under NRS 446.020. This amendment also prohibits a sidewalk vendor from operating at special events unless that vendor has obtained a full health permit and meets the relevant requirements. Additionally, it clarifies the initial registration of sidewalk vendors requires a fee as determined by regulation or ordinance, and that the renewal is annual with a fee and then must include a self-certification letter confirming no changes in food items, equipment or cart design, and operating locations has occurred since the initial registration. Item number 6 from the Northern Nevada Public Health Amendment requires a sidewalk vendor to comply with any additional zoning and distance requirements that have been set forth by a county or city ordinance. Number 7 adds provisions that clarify while expedited review of a sidewalk vending application is permissible, that they may not completely bypass the plan review process. And lastly, it requires a sidewalk vendor to post a notice sign on their conveyance that reads, "Made in a compact food cart operation that is not subject to government food safety inspection." And that is the last amendment, Chair. Thank you.
Thank you, Mr. Florence. Members, questions? Sure. Assemblymember Hibbets.
Thank you, Chair. In reviewing this bill, I ran across, and this may have been covered in the amendments because there were about 70 of them, but I'm not sure. Page 7, line 25, under section 13 is the word, I'll just read it, it's number 2, authorized use of modular conveyances that can be dissembled, which I believe is supposed to be disassembled because the definition of dissembled is conceal one's true motives, feelings, or beliefs. So I don't think that word really fits in there. So if we're going to do all these amendments anyway, can we change that to the correct word while we're at it?
Thank you. Legal, do you have an opinion on that? Are you good?
Thank you, Chair. Dave Noss, LCB Legal, for the record. That does sound like a typo, and we can make that change.
Thank you, Mr. Noss. Thank you. Assemblymember Gonzalez.
Thank you so much, Chair. My first question is on section 11, well, just very much the last page of this work session document at the very top. It talks about seizure of the food beverage is permitted. Who would be doing that seizure? And is there any warning that this person would get first if they weren't in compliance prior to the seizure of their cart, beverage, or things? And then my other question, while I see the senator coming up here, is the health district amendment a friendly accepted amendment? Thank you.
Thank you, Senator. Feel free to go ahead and answer. Thanks for being here.
Thank you so much, Madam Chair. Fabian Nyata for the record, and thank you, Assemblywoman, for that question. I'm going to break your question into 2 parts. The first one being the seizure of equipment. So, generally, the health district has already seized equipment and so forth. This is something that they have done, as has been referenced over the last 2 years since we passed Senate Bill 92. There have been questions as to whether or not the county or local jurisdictions can be the ones that can seize equipment or impound as well. And so that actually was an agreement that we had as part of the work session document in the Senate, but it was left off in the reprint. And so that's why we're putting it back in. I mentioned that as one of the questions that we received during the presentation in this chamber was that essentially what happens in the instance if someone sets up across the street from another business, a brick and mortar business. So this is the provision of the bill that says nothing in the ordinances have been changed. It's just we now have the ability to impound and remove equipment. Now, to your second question, just really quickly. So
Wait, sorry, Senator. I don't mean to interrupt before I get there. I just want a clarification. So are we giving a warning before we're seizing people's equipment? Is that part of... Can you walk me through that really quickly? Sorry.
Yes. Joelle Gutman Dodson for the record, Northern Nevada Public Health. Typically, health districts don't seize equipment. We confiscate food. And typically that is on a complaint basis. So we get a complaint. If we go out and deem that this is unpermitted or, out of regulation, we can confiscate food. The seizing of equipment is a county issue, and I will let Joanna Jacob answer that. Thank you.
Good afternoon, Joanna Jacob on behalf of Clark County. The language included that was left out in the reprint was actually something that Clark County had worked on with Senator Giannate. And the issue that we are facing, I'll just give you the context, is there's been a lot of illegal restaurants that have popped up in Clark County. Perhaps the members have seen it. And typically, who is enforcing that? It's Clark County Department of Business License. We have the business license people that go out, and I know that their typical process is about compliance. So it's a notice first, hey, you're not supposed to have this here, right? And then it is also complaint-based, as Joelle noted, but we typically will give a notice and educate about why you shouldn't have an illegal restaurant on the side of the road in Clark County. And that's the typical way that we enforce it, unless there's an emergency. Then there might not be without notice. So I can be happy to, if you have further questions, when we get back out of session, you can come in and walk through our process. Happy to bring anybody from this committee to kind of understand how we would use that language. And the issue was because if we can't confiscate, then it actually remains. So that's the problem that we have that we're trying to address. Thank you.
Thank you, Chair. Thank you so much. I just wanted that clarification that we weren't confiscating food vendors' things without providing some sort of a warning first or things like that. And this wasn't mentioned, or if it was, I missed it in the hearing. So I appreciate the clarification, and we can definitely talk more offline. And then, Senator, if you want to answer the second question.
Thank you so much, Fabian Iñarte, for the record. So this is my first time reviewing the work session documents, so just give me your patience. I believe that there was a mistake with what was included. I think there was a separate document that I had made revisions earlier to this morning. The page, I'm looking at page 7 of the work session document that's attached to this. There's distance and size restrictions. The original proposed amendment that was submitted was a distance requirement that a vendor cannot operate within 1,500 feet of a permitted food establishment. I did not agree with that. I mentioned that it should reflect any distance requirements in this bill should reflect to what the ordinances that have already been passed. I don't want the cities to be in a position of having to revise and go through the process of changing their ordinances. It should stay the same. And so I just wanted to make that clear in the record as they start drafting it. And I think it might just have been the mix-up because we were working on this morning.
Thank you, Senator, for that clarification. I think we had a lot of amendments, and we were trying to not lose anything of importance. So we appreciate you clarifying that on the record. Thank you. Any other questions, members? Okay. Thank you so much for being here to answer questions. I will entertain a motion to amend and do pass. So moved. Motion by Vice Chair Wynn, second by Assemblymember Hunt. Members, any discussion on this motion? Discussion. Assemblymember Hafen.
Thank you, Chair. First of all, I want to thank the bill sponsor and all the stakeholders that have worked on this. I know I think it was mentioned 70 amendments that were added today during the work session. And I know a lot has gone into this. I'm going to vote yes out of committee today. I'm going to reserve my right so I could fully review the 70 amendments on the floor once the actual language comes out to make sure we don't have a dissembled technical adjustment that needs to be fixed. But again, I just want to thank the bill sponsor, the chair, staff, and all of everybody that has worked so hard on this bill.
Thank you. Assemblymember Hibbets.
Ditto.
I appreciate the ditto. Thank you for that. And I would just like to clarify the record. We have not counted the number of amendments, and so I believe that 70 may be a fictional number currently, just so we're clear, okay? Well, there were significant amendments. I don't believe there were 70. Okay. We have a motion. All those in favor say aye. Aye. Any opposed, nay. Motion carries. Congratulations. Thank you. I will give that floor statement I will take that floor statement. Yes. Next on our agenda is Senate Bill 299. Mr. Florence.
Thank you, Chair. Davis Florence for the record. Senate Bill 299 in its first reprint revises provisions relating to senior living communities. This was sponsored by Senator Dondero Loop et al. SB 299 removes the requirement for a senior living community referral agency to obtain a license from the State Board of Health, and instead requires such agency to register with the Division of Public and Behavioral Health. And there are no amendments to this bill. Thank you, Chair.
Thank you, Mr. Florence. Members, any questions? Seeing none, I'll entertain a motion to do pass.
So moved.
A motion by Vice Chair Nguyen. Second by Assemblymember Nadeem. Any discussion on this motion? None. All those in favor say aye.
Aye.
Any opposed, nay. Motion carries unanimously, and we'll give that floor statement to Assemblymember Hunt. Thank you. Next on our agenda is Senate Bill 306. Mr. Florence.
Thank you, Madam Chair. Davis Florence for the record. Senate Bill 306 in its first reprint revises provisions relating to mental health services for children. This was sponsored by Senator Cruz Crawford and Assemblymember Mosca. There was an amendment submitted by Aisha Goins, Joanna Jacob, and Cadence Matievich in collaboration with Chair Brown May. In summary, it proposes to do two things. First is to delete the existing provisions of the bill, but retain Section 3, Subsection 2, and the provisions that require that discharge procedures prohibit the discharge of a child to a temporary facility unless that is the placement of last resort. And the second item would require the Division of Child and Family Services to convene a work group of stakeholders, including representatives of child welfare, juvenile justice, and children's mental health, to develop a recommendation for a program to provide services, including housing, to certain youth. And that is the last of the amendments, Chair. Thank you.
Thank you. Mr. Florence, I just have one question. With regard to the proposed amendment that we received, there is in red, we struck out refusal and changed the word to inability, and then identify whether a youth poses a health and safety risk of the parents. And I'm curious to know if I believe that came up in conversation that we were going to eliminate that language so that we are not pre-diagnosing a youth or placing blame on parents because of the situation. Is that accurate? Can we add that into the work session document?
Thank you, Chair Davis Florence. For the record, yes, we can add that to, instead of the recommended language in the amendment that reads, due to the risk the presence of the youth poses to the health and safety of the parents, other children, or other members of the household, to instead read something along the lines of due to the potential risk to the health and safety, and to revert the language from inability to refusal of the youth's parents. Thank you, Chair.
Thank you. I think it was other way, though, from refusal to inability, right? Instead of a parent. A parent is not, I just want to be really clear that a parent's dealing with a potentially high-risk situation may have an inability and needs diagnosis of the child. I just want to make sure we're not placing blame on the child. And perhaps we can work that through with legal as we work on the amendment. But really just wanted to get that on the record, that we're not blaming parents and we're not blaming children. We're simply trying to find the right resources. Okay, I'm getting nods from the interested people in the audience. Okay. All right, members, questions? Okay, thank you. I will entertain a motion to amend and do pass.
So moved.
Motion by Vice Chair Nguyen. Second by Assemblymember Gonzalez. Is there any discussion on this motion? Assemblymember Hafen.
Thank you, Chair. I think this is the most I've talked during this committee, so I appreciate the time and the indulgence. Concerns that were brought up by the Attorney General's office regarding the DOJ settlement. I had very good conversations with the Attorney General's office and the bill sponsors. I believe we're good. I believe that everything is going to be fully satisfied and not be an issue. And so I'm going to be a yes at a committee today. I'm going to reserve my rights on this, just pending any changes from the Attorney General's office giving direction. And I've actually talked to a bill sponsor if there is a correction that we need to make on the floor. And then hopefully, if that is the case, I'll still be a yes. Thank you.
Thank you, Assemblymember Hafen. I appreciate that on the record. Any other discussion? Okay, all those in favor say aye.
Aye.
Any opposed, nay. Motion carries unanimously. Thank you. We will give this floor assignment to Assemblymember Mosca. Next on our agenda is Senate Bill 330. Mr. Florence.
Thank you, Chair. Davis Florence for the record. Senate Bill 330, in its first reprint, revises provisions relating to facilities for skilled nursing and was sponsored by Senator Neal. This bill was heard on May 5th. SB 330 amends the definition of facility for skilled nursing to clarify that facilities for skilled nursing provide inpatient care. Additionally, the bill requires each county and a city to adopt an ordinance using the preceding term in the Nevada revised statutes to describe a facility for skilled nursing, and there are no amendments to this bill. Thank you, Chair.
Thank you, Mr. Florence. Members, any questions? Seeing no questions, I will entertain a motion to do pass. Motion by Vice Chair Nguyen, second by Assemblymember Hunt. Any discussion on this motion? Seeing none, all those in favor say aye. Aye. Any opposed, nay? Nay from Assemblymember Hafen. Thank you. Motion does carry. We'll give that floor statement to Assemblymember Nadeem. Next on our agenda is Senate Bill 348. Mr. Florence.
Thank you, Chair. Davis Florence for the record. Senate Bill 348 in its first reprint makes revisions relating to laboratory testing. It was sponsored by Senator Pizzina et al. And was heard on May 5th. There was an amendment submitted by Senator Pizzina which proposes to change the fee the state public health laboratory may charge to $122 starting on July 1st of 2025. On January 1st of 2026, the laboratory may increase the fee up to $150 if the new fee is not greater than the reimbursement rate paid by Medicaid. And second, this amendment requires the Department of Health and Human Services, to the extent that federal financial participation and state general fund resources are available, to seek federal approval to provide a reimbursement rate of up to $122 for certain examinations and tests required for the discovery of preventable or inheritable disorders in infants. This rate must be established separately from the reimbursement rate for other labor and delivery services, and there is the option to extend that rate up to $150 for services paid by Medicaid starting on January 1st upon federal approval. Thank you, Chair.
Thank you, Mr. Florence. Members, any questions? No? No questions? Okay, I will entertain a motion to do pass. Thank you. Motion by Vice Chair Nguyen. Okay. Amend, do pass. Sorry, to entertain a motion to amend and do pass. Thank you for that catch. A motion by Vice Chair Nguyen. Second by Assemblymember Gonzalez. We have a discussion. Go ahead. Assemblymember Coe.
Thank you, Chair. I'm going to vote yes on this today, but I'd like to reserve my right to change my vote on the floor.
Any other discussion, members? Okay. All those in favor say aye. Aye. Any opposed, nay? Nay from Assemblymember Hafen. Motion does carry. Thank you so much. We'll give that floor statement to Assemblymember Gonzalez. Thank you, Chair. Thank you. Next, we have Senate Bill 372. Mr. Florence.
Thank you, Chair. Senate Bill 372 revises provisions relating to the care of children. It was sponsored by Senator Steinbeck. This bill was heard on April 30th. SB 372 adds to the list of circumstances in which a child is not considered to be abused or neglected, and the health or welfare of the child is not considered to be harmed, threatened, or injured, to include the following instances: when a parent or guardian seeks to have the child admitted to a mental health facility or hospital if the child's behavioral health needs pose a risk to the safety and welfare of the family, and brings into the child's home a biological, foster, or adoptive child whose behavioral health needs pose a risk to the safety and welfare of the family. And there are no amendments to this bill. Thank you, Chair.
Thank you. Members, any questions? No questions. Thank you. I will entertain a motion to do pass. So moved. Motion by Vice Chair Nguyen. Second from Assemblymember Hafen. Okay. All those in favor say aye. Aye. Any opposed, nay. Motion carries unanimously. Thank you. We'll give that floor statement to Assemblymember Ornlicker. Thank you, Chair. Thank you. The last item we have on our agenda for work session document today is Senate Bill 408.
Thank you, Chair. Davis Florence for the record. Senate Bill 408 in its first reprint revises provisions relating to county hospitals and a county hospital district. This was sponsored by the Senate Committee on Health and Human Services. SB 408 authorizes county hospital districts to employ and fix the compensation of dentists. It also allows county hospitals and county hospital districts to employ medical and dental residents and fellows, but not interns. And finally, it allows county and district hospitals to enter into a contract to provide or form a separate organization to enter into a contract to provide crisis stabilization services or certain other mental and behavioral health services. And there are no amendments to this bill. Thank you, Chair.
Thank you, Mr. Florence. Members, any questions? Seeing no questions, I will entertain a motion to do pass. Thank you. Motion by Vice Chair Nguyen. Second by Assemblymember Nadeem. Is there any discussion on this motion? Seeing no discussion, all those in favor say aye. Aye. Any opposed, nay. Motion carries unanimously. Thank you. We'll give that floor statement to Assemblymember Koenig. Thank you. That is our work session for today. Really great work. I want to congratulate our members, our staff, the team from the Legislative Council Bureau's Legal Division, all of our committee staff, our committee secretaries. Really good work. And that moves us to the next item on our agenda, which is public comment. If you would like to offer public comment here in Carson City or in Las Vegas, please come forward at this time. Seeing no one here to offer public comment and no one in Las Vegas, AVH, is there anyone on the telephone line who would like to offer public comment at this time?
Chair, the public line is open and working, and there are no callers at this time.
Thank you, AVH. We appreciate that. That concludes our business for today. Members, we are going to post an agenda for Friday at call of the chair. We don't currently have work coming to us, but that does not mean something will not come up. We will probably have a committee hearing next week, so that we do know that there are bills coming over from the Senate, so please don't think that we have concluded our work and we're done. We are not officially done, and there will be more coming our way. So just know Friday is call of the chair. We'll let you know as soon as we have more information. And with that, this meeting is adjourned.